Welcome to today's employer webinar, COVID-19, your top HR and JobKeeper questions answered. My name is Sarah Hills. I'm a senior HR consultant at Perks People Solutions, Perks HR consulting business. I'd like to introduce Cecilia White, Director of Perks People Solutions. Cecilia has a legal background with 10 years experience as an employment lawyer in private practice and now heads up the HR consulting arm at Perks People Solutions, advising business owners and employers on all HR and workplace relations matters, awards, contracts, disciplinary matters, investigations, equal opportunity and HR policy development. We also have Perks Tax Consulting Director, Neil Oakes, online today to answer any JobKeeper questions you may have from a tax perspective.
Good morning, and thank you, Sarah. Thanks for the introduction and welcome everybody. Thanks for joining us for our webinar this morning. I hope everyone's managing okay out there in these pretty bizarre times. It's obviously been a really busy few weeks for a lot of people as we start to get our head around some of the implications, I guess, of COVID-19, but particularly what's come up in the last week or so, many questions regarding JobKeeper. So we will spend most of the session today focusing on JobKeeper questions, with a bit of an introduction on some other matters and factors for consideration as well. A little bit of housekeeping before we start. You will see, hopefully, either at the top or bottom of your screen is a toolbar which has a Q&A function. You can see the little Q&A icon there. Throughout the session, you are more than welcome to submit any questions that you have using that button. Those questions will either be addressed live throughout the session by our moderators, and we will also open some of those up at the end of the session for answers as well. So whether you've got questions relating to HR matters or whether you've got questions that are more specifically related to eligibility, and therefore we've got our tax expert Neil Oakes online with us today, and he'd be happy to answer any of those particular eligibility questions as well. We have around an hour thereabouts set aside for today's session. I'm hoping to cover off most of the content in around 45 minutes, leaving around 15-20 minutes for questions at the end. We'll move through at a relatively rapid pace. Don't worry if you miss anything or if you get called away on a phone call, or if you have any technical issues at all throughout the session. Everyone who's registered today will receive a recording of the session as well as a copy of the PowerPoints as well. So don't stress if you miss anything. You'll have all of that information straight to your inbox within a couple of days from today's session. So let's get started, shall we? In terms of what we're going to cover today, I'll spend a little bit of time at the front end addressing some of the practical, I guess, considerations and implications for employers around COVID-19 and how to manage it in your workplace, particularly around work health and safety. So we'll talk about things like the self-isolation requirements and how to manage that, how to ensure that your people are safe and what your obligations and, I guess, rights are as an employer in that setting. Then we're going to move on to talk through how you are managing or how you can manage the structure of your business to deal with some of the challenges that we're all facing as business owners. So whether that means scaling down some of your business operations and therefore your staffing requirements, or whether it means potentially for some employers enforcing stand downs across part or all of your workforce, or whether it potentially means more permanent solutions such as redundancies. We'll talk through what those options look like and what some of the considerations are for you, depending on where you sit and what you're considering for your business. There have also been a number of recent award changes that we're going to flag today as well, some specifically relating to industries such as restaurants, hospitality. Also the Clark's Private Sector Award have had specific variations made to those awards, which may affect some of you in your industries. There have also been more broad sweeping changes to modern awards as a whole. Around 99 or so modern awards have had a couple of extra provisions included on the back of COVID-19. So we'll talk through what they are and how you might be able to utilise some of them in your businesses. Then we'll get stuck into probably what is the meat of today's session, which is JobKeeper. No doubt everyone has spent the last at least week or so grappling with some of the JobKeeper questions, eligibility criteria, working out what it means for your workplace, whether you can access it, whether you want to access it. So we'll spend some time going through some of the questions there. And thank you for those who have submitted questions prior to the session today. We've done our absolute best to make sure we've answered those questions throughout the PowerPoint presentation. However, if you don't, or if we haven't got to your question, please feel free to submit it back to that Q&A button, and we'll make sure that we try and get those answers to you. I think probably safe to say that over the last few weeks, or month, I guess, really, since COVID-19 really hit us in a business sense, things have really changed at an incredibly rapid pace. I do have a feeling over the last week or so that it's settled down slightly in the sense of the immediate panic, I suppose, of COVID-19 and what it meant for all of us as business owners. There's certainly been a pickup in pace around getting our heads around JobKeeper. But I think suffice to say, it's been a very rapidly changing environment, and everyone's trying to keep up with the various changes, announcements, government announcements, rulings and the like. And certainly the nature of the inquiries that we've been dealing with here at Perks have changed, you know, over that time. There was certainly in the early days quite immediate concerns about safety and those fairly acute issues around what it meant for people's business and the operations of people's businesses in those early days, and trying to grapple with some of that. And now we're certainly seeing people who are in a bit of a different environment now. Perhaps they've stood people down, perhaps they've put some of those workplace changes into place, and now they're going through that process of applying for JobKeeper, or really just trying to keep things rolling as best they can over the next little while. So certainly the nature of inquiries has changed. But I think the common theme amongst all of this is that, you know, whilst we can certainly advise on key requirements and obligations, and there's a lot of information out there from a lot of different sources, certainly what we're seeing is that there's no real one-size-fits-all approach, and the advice that you need for your business and your circumstances really needs to be tailored advice, taking into account all of the various factors that apply to your operations, your finances, your cash flow, your workforces. So specific and tailored advice is really, really important, I think, at a time like this. You really do need to closely consider your obligations under any relevant awards that might be in place for your industry, enterprise agreements, workplace contracts, workplace policies. So all of those things that are really specific to your business need to be considered alongside the broader requirements and general guidance and obligations as well. And you might find as you're trying to work your way through this as an employer that you've got competing duties. You've obviously got your responsibilities, fiduciary responsibilities as a business owner and an employer to maintain, I guess, the viability of your business and make decisions, sometimes tough decisions, in order to achieve that. But at the same time, you're wanting to look after your people and your employees. You know, they're your asset as well, and you know that you're going to need them back on board when things do scale up again. So sometimes it can pose some really tricky questions for business owners when you're trying to manage those two sets of responsibilities. Okay, so covering off first of all on some of the WHS considerations arising out of the COVID-19 pandemic. Probably the main questions that we have been receiving over the last little while have been around self-isolation and how do I as an employer ensure that my staff are safe, that I'm doing what I need to be doing as a business owner if we're still operating, bearing in mind a lot of you may have had to close your doors for a period of time, but there may well be some of you that are still operating and still having to factor in some of these obligations. So obviously to prevent that infection spread, the government fairly early on in the piece and relevant health authorities implemented those self-isolation requirements that are mandatory in a number of circumstances, particularly those relating to people who've travelled or people who've come into close contact with someone who's a confirmed case. Now, depending on your workforce size, how you set up, the physical environment of your workplace, those requirements will potentially impact on your staffing arrangements, your rosters, how you actually staff your organisation, and they do require you as an employer to take fairly proactive steps under work health and safety legislations to protect and prevent infection spread and to ensure the safety of your staff. And they've also then triggered lots of queries from employees about what are the implications around leave requirements, for example, or leave entitlements during those self-isolation periods. Our advice is obviously always ensure that you're up to date with the latest government guidelines, and I think we're going to probably see over the next little while those guidelines start to change and shift a little bit now that we're seeing that curve flattening. So make sure you're getting your information from up-to-date sources. If you are concerned about potential infection spread in your workplace, you can lawfully direct an employee to work from home if that is feasible. Now, we know that that's not always going to be possible depending on the type of business, depending on the type of role that that person performs. If they can't work from home and you have directed them or a number of people to stay home out of precaution, you will need to pay them their ordinary wages for that period of time. Now, obviously, unless they are already stood down without pay, then you're not required to pay them in those circumstances. But if your business is operating, you're still trading, and you've made the call as an employer from a safety perspective to make or require people working from home, then you need to ensure that they're paid for that period of time. We have had employers come to us and say, look, I've got an employee who doesn't feel safe coming to work. We believe as an employer we've got everything in place here to ensure their safety. We're complying with social distancing. We're doing what we need to do, but yet we've got an employee who is unwilling or doesn't feel comfortable coming to work. Perhaps they may be medically vulnerable themselves, or they might live with someone who is. In that situation, if they are not able to work from home, obviously that's your default. If someone can work from home, then you should do what you can as an employer to set that up for them. But if they can't, if that's not possible or feasible, and if they're not unwell themselves, so they're perfectly fit and healthy in the sense that they're not unwell as a result of COVID, or they're not caring for someone who is unwell, so essentially they don't have access to sick leave in that circumstance, they can take their paid annual leave. That's discretionary. So you don't have to allow them to take their annual leave if you don't want to as an employer. That is up to you. You can choose to allow them to access their annual leave to cover that period of time. And if they've exhausted their annual leave and they're still not comfortable coming back to work, then you could look at leave without pay by agreement as well as another option. If obviously if the employee is displaying signs of illness, that's a different story. You can direct them to leave the workplace, ask them to obtain a medical certificate certifying that they are fit to return from work. So obviously out of an abundance of caution, if someone is displaying any of the symptoms of COVID, and we're probably all really familiar with what they are now, obviously fever, cough, sore throat, runny nose and the like, if they are displaying those symptoms, you're within your rights as an employer to request that they seek medical clearance before they do return to work. Now, if they refuse to do that, or essentially they're refusing to follow what's considered to be a lawful and reasonable direction, you could go down the path of dealing with that as a disciplinary matter. Hopefully that's not something you would have to come across often, and most employees are understanding of the need to go to these extra safety lengths at the moment. If you do require that someone leave work to go and obtain that medical clearance and medical certificate from their doctor, you will need to pay them for that period of time. That's a direction from you as the employer to go and obtain that clearance. So it's fair and reasonable that they should be paid for that period of time. Working from home, This is obviously something that many employers have had to put in place pretty rapidly over the last few weeks and get people set up to work from home. But I guess the question has come up, do we have an obligation as an employer to allow people to work from home? You know, what are our obligations there, particularly from a work health and safety perspective? So the work health and safety laws do require that employers take all reasonably practicable steps to ensure the health and safety of their employees. But that includes both physical and psychological health and safety. So the answer, I suppose, to that question is that if it is reasonably practicable for you as an employer, taking into account what it is that this employee does, what their role is, what their tasks are, but if it's reasonably practicable to have employees working from home, then you should take steps as an employer to allow that to happen and to facilitate that. Not only do you have to consider what their tasks are, what's their role, how are you going to manage that work from home, you know, those practical considerations. If you're going down the path of having employees working from home, and understanding many of you may already have done this and put this into place, but for those of you who haven't, obviously you need to ensure they've got the right equipment and the right infrastructure to be able to work properly from home. We would always recommend you have a good up-to-date work from home policy, which outlines what their obligations are, what their rights are, and what the requirements are around that working from home arrangement. We would recommend a working from home checklist, and that's essentially from a safety perspective, because technically, if somebody is working from home, that is considered to be the workplace, which is relevant from the perspective of workers' compensation. So if someone were to be injured whilst working from home, potentially they could have a workers' compensation claim against the employer. So you really are best advised as an employer to make sure that their setup at home is safe to mitigate and minimise any risk of injury. The employee may also work in a role where they have access to commercially sensitive or private information. If they're working from home, you want to ensure you've got a privacy policy in place so that they're aware of what their obligations are around that information, and that only the people that need to access that information have that access, and there aren't people within their homes who have unauthorised access to private information. So some of the practical considerations around working from home are really important. If you're not sure about which roles can be performed at home, then you may still need, or you know, there's perhaps just some roles that can't be performed from home, and you still have a number of employees at the work site. Make sure that you're just referring regularly to guidance from the relevant Department of Health, Safe Work Australia for guidance on how you manage people's safety who are still at work in the workplace. Just briefly, a note about mental health and well-being of your employees. It's a really difficult time at the moment for a lot of people for a lot of different reasons, but you know, working from home in isolation without contact with colleagues or clients can really potentially impact on people's psychological well-being. So as an employer, your obligation is not only to look after their physical safety, but also to ensure their psychological safety as well. So I think it's really, really important, and probably more important now more than ever, to ensure that your employees are travelling okay and that you're checking in on them and making sure that they're looking after themselves during this period. Regularly fortnightly check-ins with individual employees. We would always recommend one-on-ones as well as team conversations as well. There's lots of ways you can set this up now. Zoom is obviously a fairly useful platform in that sense. Microsoft Teams, other ways that you may choose to reconnect as a team are really important, but make sure you've got something regular in place if you do have your employees working, I guess, in different locations from home and the like. Even if they're stood down potentially and they're not working at all at the moment, I think just as equally important to check in with them regularly and see how they are going and keep those lines of communication open. For those of you who are perhaps looking for more guidance or support around managing employees' wellbeing, there is another webinar coming up soon run by Sarah Hills from our team and she'll delve into these areas in a little bit more detail and provide some really great practical advice for employers around managing employees' wellbeing at this time. So do stay tuned for that information when that's out. But some fairly simple and brief guidance here today. It's just really a matter of checking in with people. How are they coping? Some may be dealing with it better than others. Some people who are extroverts rely on other people around them to get their energy, and will potentially be struggling a lot in that regard. Your introverts might be loving it. They might be loving the fact that they can be at home and it's quiet, but again, everyone's different, horses for courses, so making sure you're checking in with people. If you're sensing that they're really struggling, ensuring that they get a referral to professional help if they need it. Some of those conversations might be uncomfortable, or it may be stuff that you're not used to doing necessarily as an employer, depending on your relationship with your employees, but it's still a really, really important part of managing that employment relationship and also really complying with your work health and safety obligations. Okay, so moving on now to, I guess, the nuts and bolts of workforce structure and workforce management and how people are, I guess, dealing with the various challenges of COVID-19 at this point in time. I'm going to talk about, I guess, 3 different strategies or approaches that businesses can look at in these sorts of difficult times during economic downturn, financial downturn caused by this pandemic. The first is this sort of scaling down option. That typically looks like decisions taken or made by a business to potentially reduce people's hours, reduce the number of shifts, reduce the number of employees on at any given time in an attempt to really bring down those wage costs and overheads as much as possible during a time of downturn. So we'll talk through what that looks like and what are some of the requirements are there. Then there's the stand down option, which, you know, looking through the list of attendees today, I know that already some of you have had to stand down your employees. So that is done where a business is temporarily unable to usefully employ its employees, some or all of its employees, due to a stoppage of work that's outside of the employer's control. And the classic case that we've seen in the last little while is the direction by the government for certain types of businesses, non-essential services, to actually close. So that's a fairly classic situation where those stand down provisions have been enacted. Then finally, we'll talk about redundancies. Redundancies I would describe really as a last resort option for employers, as it is a permanent decision to reduce headcount due to a significant downturn or closure of a business. Typically speaking, what we're seeing is organisations going through the scaling down option, perhaps the stand down option as well, particularly now that we've got the JobKeeper available. But nonetheless, some businesses are having to make tough decisions around more permanent reduction of headcount, knowing that it could be quite some time before that particular business is going to be able to scale up to its sort of full capacity again, and there need to be some more longer term options looked at. So we'll talk about what some of the considerations are around redundancies. What we're going to do is, obviously, when we're looking at scaling down, stand downs and redundancies, is talk in this part of the section anyway, in quite general terms, what are the general requirements under Fair Work Act. But it's also really important, I think, to point out here for any of you who are covered by the Restaurant Industry Award, Hospitality Industry Award, or the Clerks Private Sector Award. There are some specific changes to those awards which apply to scaling down and standing down as well. So make sure you're across what your specific award says and whether you're covered by one of those. We'll talk about that in a bit more detail in a minute. But also JobKeeper. So we'll talk about, generally speaking, what the Fair Work requires and allows and enables. But we also know now that the Fair Work Act has been amended with these JobKeeper provisions, which may well apply to some of you out there, if not all of you. So I suppose what I'm saying is, in a nutshell, is that if you are not eligible for JobKeeper, as an employer, and some of you may not be, or some of you may have chosen not to participate in the scheme, or if you have employees who are not eligible for JobKeeper, you can either use the new, I guess, updated flexibility provisions in some of the awards, or you essentially default to just the standard Fair Work rules and Act. Okay, so in terms of scaling down, one of the main questions that we've been getting from clients is that the situation where, look, my business is very much struggling due to COVID-19. We are still trading, but business is very slow. Can I reduce my staff's pay or hours? So again, leaving aside JobKeeper for the moment, which we'll talk about a little bit later and what the rules are around that, but assuming you're not eligible for JobKeeper or you've got employees who aren't eligible for JobKeeper, the first place you go to is your relevant enterprise agreement or award, or employees' contractual entitlements, and see what might be available to you in there. Generally speaking, as a general rule, an employer cannot unilaterally reduce an employee's contractual entitlements, including their contracted hours or their salary. So you can't, again, leaving JobKeeper aside, you can't issue a direction or force an employee to take a pay cut or to work reduced hours. The only way of doing that is to do that through a process of consultation with impacted employees and obtain their consent and their agreement to do that. Thankfully, what we're seeing predominantly at the moment is a lot of employees get it. They understand the need to put some of these things into place. A lot of them understand that in an attempt to save as many jobs as possible and to keep the business as viable as possible, everyone is having to take a bit of a hit. So that does mean quite broad sweeping changes across workforces to reduce hours and in some cases reduce salaries, either or. So the consultation is really important. Communication is really important. Obviously, if you've already got really good relationships with your workforces already, that will put you in pretty good stead to be able to have some of these conversations. Once you, or if you do reach agreement with employees, then absolutely critical that you put those agreements in writing. It can be an email, it can be by way of a letter. It doesn't really matter what format it is in, as long as there is a written record that an agreement has been reached, that there is an agreement about how long that agreement is going to be in place for, and also making it really clear that that agreement and the variation to the hours or the variation to their salary is going to be subject to ongoing review based on the needs of the business. So they're the key things that you should cover off on in those written agreements. Another question around scaling down options. There isn't enough work for my employee or employees to do at the moment due to COVID. So we've seen a real, I guess, shrinkage in workload. Can I direct them to take their annual leave, or can I just tell them to take some leave without pay? In certain circumstances, employers can direct staff to take annual leave, for example, where they have excess leave. Excess leave is usually anything more than 8 weeks or so. So most awards will allow you to direct staff to take annual leave. You can also do this by mutual agreement. So often it's a matter of just sitting down, having those one-on-one conversations with your employees, talking about and being honest about where things are at as a business, and entering into an agreement with them to perhaps take some annual leave at this sort of time when things aren't particularly busy. Again, if it's done by mutual agreement, make sure that there's a written record of that agreement. Similarly with long service leave, and I know that there's people dialing in today from different states, and make sure you check your state legislation, but most state-based long service leave acts will allow for employers and employees to enter into an agreement to take some long service leave in small portions, a day at a time or a couple of days at a time, rather than having to take the whole lot at once. There is that facility or that ability in most state long service leave acts. Of course, leave without pay can be done by agreement as well. It might be, again, a matter of having a fairly open, honest conversation with an employee around that. Of course, the JobKeeper laws that we've seen in the last week or so, a couple of weeks introduced, give us as employers a little bit more ability to have these conversations. So we'll talk about that when we talk about JobKeeper. But for those of you who aren't eligible for JobKeeper or who aren't intending on applying it, that's just some guidance with you around having people access some of their leave. Stand down. So when in the early days, I think, of COVID-19, we were seeing in the media and just generally a lot of organisations having to stand down their staff, and we were getting a lot of questions from businesses about whether they could stand down staff and what that meant and what their obligations are. So just to touch on this, again, we're not talking about JobKeeper stand downs, we're just talking about stand downs in the general sense of the Fair Work Act. The Fair Work, Section 524 of the Fair Work Act contains the stand down provisions, and it applies when a business is forced to temporarily close due to a stoppage of work that the employer cannot be held responsible for. So certainly those situations where we saw a number of non-essential services having to close, restaurants, cafes, pubs, beauticians and the like, all of those services that were forced to close because of a government direction, that would be a fairly cut and dry case of where those stand down provisions are available to those employers. So what it means is those employees could not be usefully employed within those businesses, doors are shut, due to a forced stoppage of work, so that government direction, which is completely outside of the control of the employer. And in those cases, those employees could be stood down without pay until the stoppage has lifted. You know, typically up until this point, we've only really seen these provisions used in situations of perhaps natural disasters or breakdown of machinery. You know, some of you from South Australia may remember the Thomas Farms fire. So those sorts of situations is where we've usually seen these provisions used. The circumstances of the recent weeks are fairly new, using these provisions in the case of a pandemic, but there certainly were a number of businesses who were able to access these stand down provisions once those closures were made. And just a quick note on what it means by usefully employed. If an employee can still perform some form of work that is of net benefit to the employer, so we're not just talking about made up work, but if there's some work that can be done that the employer is going to benefit from, and that work is there and it's available, then they're not able to access or use those stand down provisions. So related to the question of stand down, the question here is, we are permitted to continue with some of our business operations, but due to the government's directions on social distancing, our revenue has been significantly impacted. Can we stand down some or all of our staff until things pick up again? Again, leaving JobKeeper aside for the minute, usually employers can't rely on those stand down provisions in a situation where there's simply a downturn in business or demand, or just a general slackness of trade. We certainly did see a number of particularly retailers stand down their staff, even though there was no government direction that they close. They made that call to stand people down based on that sort of demand, lack of demand, lack of foot traffic, lack of sales. Questionable whether that was, I guess, lawful or not in those circumstances prior to sort of the JobKeeper stuff coming out. But really, you know, our advice is if you're not eligible for JobKeeper and you haven't been forced to close by virtue of a government direction, be very, very careful proceeding with a stand down without getting advice first, because it might be that you don't necessarily meet the criteria or not able to satisfy the provisions in the stand down section of the Act. Stand downs can be win-win for employer and employee. It allows you to really I guess, reduce those overheads while things are really slow, but it's not without risk. So before going down that path, if you're not eligible for JobKeeper, make sure you undertake a proper analysis of your business and get the right advice before you go down there. It'd be interesting to see whether we see any fair work cases on the other side of this where employers potentially have utilised those stand down provisions when they weren't actually available to them. So during a stand down, we've been forced to close. So that's your fairly black and white case there. We're a non-essential service. I've been forced to stand down my staff. Do I have to pay them anything? Sick leave, annual leave, or long service leave during that time? The answer is no, you're not required to make payments to employees during your stand down. If you are willing and able to do that, and if you've got the capacity to do that, to allow them to take their accrued paid annual leave or long service leave, you can do that on a discretionary basis. So you're not legally required to. It's important to note that during a stand down period, even though someone may not be being paid at all and they're not working at all, they do continue to accrue annual leave, personal leave and long service leave throughout that stand down period. Anzac Day is coming up, so this Saturday, I believe, and my employees are all stood down. Do I have to pay them for that public holiday? And this question obviously came up over Easter as well. So the short answer is yes. The Fair Work Act does state that where an employee is stood down, they still need to be paid for any public holidays that fall during that stand down period if they ordinarily would have been paid those public holidays. So we imagine we sort of suspend the stand down temporarily on public holidays, and if that employee would typically have been paid for that day, then yes, you do need to pay them for that public holiday. Can my employee go and work for a different employer while they're stood down? Yes, they can. We would just always recommend to employers, make sure they've sought your consent first and that you know where it is that they're working. You might need to be mindful of things like non-competition clause or confidentiality obligations under their contracts of employment if they are going to work for somebody else. And I would always recommend that consent that they've sought from you is written down, whether it's, again, just via an email, that's fine, just so that there is a paper trail there. But just remember that they will still continue to accrue leave entitlements with you for as long as they remain employed by you and are stood down, regardless of the fact that they're working somewhere else. Okay, before we move on to, I guess, the JobKeeper stuff in a minute, I'll just a quick word, I guess, about redundancies. I guess we've talked about some of those temporary measures, such as reducing hours, reducing salaries, unpaid leave, stand down, etc. if available. They will allow you or enable you as a business to reduce your costs, but they will also allow you and ensure that you're ready to just scale up again quickly when required. And that's certainly the principle behind JobKeeper as well, to keep people connected to their employment rather than having to go down a whole, recruitment and rehire process when the time comes. But we also know that due to some of the significant impacts that COVID-19 has had on a number of businesses, some of those businesses may already have been or may expect to be impacted so significantly, to the extent that a more permanent reduction in headcount and restructures of teams, etc., may really be unavoidable, and therefore redundancies may be necessary to carry out in their workplaces. So do the normal rules about redundancies still apply during COVID-19? They do. There's no change to any of the redundancy rules. So if you do decide that you need to make some people redundant, three main, I guess, requirements that you need to consider in order to avoid any unfair dismissal claims down the track. The first is you have to be really, really confident that you can demonstrate as a business that that role that person is performing is no longer required. That job does not need to be performed by anybody. You also need to comply with any consultation requirements in a relevant award or enterprise agreement. So check whether that employee is covered by an award and then check what those consultation requirements are before proceeding. You also need to be able to demonstrate as a business that it was not reasonable in the circumstances for that person to be redeployed within the business or with an associated entity. At the moment, that's pretty easy to demonstrate. Most of these redundancies that are occurring are really due to the fact that there's been significant downturns of businesses and loss of major pieces of work or contracts or sources of income. And so there aren't any other roles within businesses for people. So make sure that you've considered those 3 points before you do proceed with a redundancy, and seek advice if you're just not sure. If you do need to make people redundant, you need to obviously consider what you need to pay them by way of redundancy pay. If you employ more than 15 employees, and that headcount includes casual employees, if you employ more than 15 employees, you'll need to pay redundancy pay to those employees based on their length of service. You'll also need to pay them, or either give them notice or pay them notice in lieu, and they're also entitled to be paid any of their accrued leave entitlements as well. And if any of your larger businesses are making more than 15 employees redundant, you also need to notify Services Australia of those proposed redundancies. Just a quick, I guess, jumping back quickly to those award variations that I spoke to before. Most of their modern awards, about 99 or so of them, so I imagine a lot of you covered by those 99 awards, have had a couple of additional or a couple of variations made to them over the last little while, over the last couple of weeks. First is the introduction of 2 weeks unpaid pandemic leave. So that's there to be used in a situation where an employee is required to self-isolate due to the advice of government medical authorities or on the advice of a doctor. So they can access this 2-week unpaid pandemic leave. It doesn't affect any of their other paid or unpaid leave entitlements, and it still counts as service for the purpose of accruing entitlements. So just be aware that that's there. Secondly, there are some clauses introduced around annual leave flexibility, allowing employees and employers to enter into an agreement to allow an employee to take annual leave at half pay. So I guess being able to buy a little bit more time and stretch out their annual leave on half pay over that period of time. It's really important, obviously, that any agreement like that, again, is put in writing. Then there are a few industry-specific award variations that I just touched on briefly before. The Clerks Private Sector Award, Hospitality Award and the Restaurant Industry Award have all introduced clauses that provide more flexibility for employers and employees to, for employers to direct employees to do different work across different classifications that they might ordinarily be in, so that, again, being able to be a little bit more adaptable and flexible to do what work might be there to be done during this time. It also enables employers to direct employees to work reduced hours. So check your specific award about what that means for you if you are covered by one of those awards. And it also enables employers to direct employees to take annual leave with just 24 hours notice. Again, there are some rules around how you do that, but it does certainly open up a lot more flexibility for employers in those particular industries. Okay, so now we're going to spend some time on JobKeeper, which is where really most of the questions came from. As I said, we've gone through all the questions that people submitted, and we've tried to weave them in here. And so I'll just start with a bit of a general overview. Obviously, this legislation was passed only fairly recently, just before Easter, and then the rules were released shortly afterwards. The rules, legislation essentially inserts a whole new part into the Fair Work Act to provide for special flexibility provisions, I guess, for employers over the next 6 months. So the Act will be automatically repealed at the end of September. So really looking at covering this next period of time for 6 months. The first JobKeeper subsidy, and I'm sure you're probably all across this by now, will be payable in that sort of first week of May, but backdated to the 30th of March, and will continue to be paid until the 27th of September. So that's that 6-month period. What's the object of the Act? Well, obviously to make some temporary changes to help as many Australians as possible keep their jobs, maintain their connection to their employers during this pandemic, to help Australian businesses remain more viable during this period of time, allowing them to kind of go into this period of hibernation or semi-hibernation until we can come out the other side and rebuild. Also to ensure that there's proper and effective operation and compliance with work health and safety requirements during the pandemic as well, to minimise risk and spread of infection. and really just help employees, as many employees as possible in Australia, to remain productively, employed during this time, and keep people off the Centrelink queue essentially, and also to allow businesses to operate for as long as possible while it's still safe to do so. So who's eligible? So employees will be eligible if their business has a turnover of less than $1 billion and their turnover will be reduced by more than 30% relative to a comparable period a year ago. Their business has a turnover of more than $1 billion, and so if their business has a turnover of more than $1 billion, they'll need to demonstrate that that turnover will be reduced by more than 50% relative to the comparable period a year ago. For charities and not-for-profits, that threshold is 15% reduction in turnover, and any businesses not subject to the major bank levy are also eligible. Quick one about self-employed individuals. Yes, I've had a couple of questions on this. Self-employed individuals will be eligible to receive the JobKeeper subsidy, provided they meet the relevant turnover test outlined. So that's employers. Which employees are eligible? They need to have been employed with the business as at the 1st of March 2020. That's the date. They must be either full-time, part-time or long-term casuals. And long-term casuals means anyone who has been employed for at least 12 months on a regular and systematic basis. As at the 1st of March 2020, they need to be at least 16 years of age. They also need to be an Australian resident for tax purposes or the holder of a certain types of visa, subclass 444, which isn't open to many. It's a fairly discrete, I guess, group of people. And they also can't claim JobKeeper for more than one employer. So that question has come up a bit, where you've got employees who work across a couple of jobs. They can only claim JobKeeper in respect of one job, one employer, and typically it's their primary employer. Someone had asked a question about CEOs. So yes, CEOs can be eligible employees within the business, including within not-for-profit organisations, provided all of that eligibility criteria is met. Also, there were questions about sole traders. So some eligibility guidelines there for sole traders. They are eligible provided they're actively engaged in the entity's business, had an ABN on the 12th of March, not currently receiving any parental leave or other government dad and partner pay, not currently receiving workers' compensation, also those residency requirements as well. Also eligible if a trustee in a bankruptcy has not been appointed to your property, and some eligibility requirements regarding assessable income as well. In terms of what the JobKeeper laws enable employers to do, the mechanics of it, and how it enables them to manage their workforces, what it has done is introduce this notion of JobKeeper enabling directions. And what that does is authorises an eligible employer to give a JobKeeper enabled stand down direction to an employee. So that's a direction to work reduced hours, including a reduction of hours right down to nil. It allows those employers to issue a direction about what duties that employee performs. So it allows them to require or direct employees to do different jobs than they would normally in their ordinary role. Again, just to provide a bit of flexibility given what's going on at the moment. And also they can require employees to work at different locations, including from home, for example. Now those directions, so if you're a JobKeeper eligible employer and you've got eligible employees, the directions that you can issue here under these JobKeeper laws override any existing rights or obligations that you might have under a current award, enterprise agreement or contract. But these JobKeeper provisions take precedence over those obligations. So it certainly does provide a lot more flexibility for businesses. Just jumping back to the JobKeeper enabled stand down and what that means. Essentially what that does, as I said before, is allow employers to direct employees to reduce their hours. So you don't have to enter into an agreement like we were talking about earlier. If you can access JobKeeper and you're eligible and that employee is eligible, you can issue a direction, provided you can show that that employee cannot be usefully employed for their normal hours or days of work. And that's pretty easy to demonstrate at the moment for most people, I would have thought. It also, that inability to perform that useful work at their normal hourly rate or at their normal hours, number of hours, that has to be linked to or attributable to COVID-19. So it can include the situation where sales have plummeted, customers just aren't coming through the doors anymore. Without these provisions, those sort of businesses were stuck a bit because they couldn't really access the stand down provisions in the Fair Work Act because they weren't forced to close. It was just we were watching sales go like that. Now with JobKeeper, it does enable those businesses in that situation to effectively stand down staff during these really quiet times. So it certainly applies those stand down provisions to a much broader range of circumstances. Now, if you're going to issue a JobKeeper enabled direction as an employer, obviously you must ensure that you qualify for JobKeeper at the time that that direction is given. Again, you must be able to demonstrate that employee can't be usefully employed because of changes to the business caused by COVID-19 or government directions to close. The stand down must be safe. So, for example, if you're requiring them to work different duties, you must ensure that those duties are actually safe for them to perform. The employer must become entitled to one or more JobKeeper payments for the employee during that stand down period in order to be able to issue one of those directions. And then during a stand down, the employer must continue to meet the wage conditions set by JobKeeper. So if you issue a JobKeeper enabled stand down to, say, for example, reduce hours, you have to ensure that that employee's base hourly rate effectively hasn't been reduced at all, that you're still maintaining fair pay for the work that's actually been undertaken. You can't reduce hourly rates. You can reduce the number of hours they perform, but not their base hourly rate. Directions must be done by way of consultation. You have to give people at least three days notice, 3 working days notice before issuing a direction, or you can agree a lesser period if that employee is open to that. Again, document these directions in writing. There's some useful templates and letters and such available if you need help with that. Again, as I said before, any direction issued must not reduce an employee's hourly rate. That's what the JobKeeper laws have called the hourly rate of pay guarantee. That direction must be reasonable. So there's going to be fairly hefty penalties for employers who are seen to be using the JobKeeper directions in an unfair or unreasonable way. And it must be reasonable in order to ensure that employees' ongoing employment. That's got to be the driver behind it. The JobKeeper subsidy is there to keep people in employment. And it's also important to note that while people are stood down or while they're working reduced hours potentially, that employee continues to accrue leave at their ordinary pre-JobKeeper rate. They don't accrue leave at the reduced hours, they accrue at their full rate. So they're all the directions that you can issue, those sort of unilateral one-way directions that you can issue as an employer, provided you follow all of those steps and meet all that criteria. There are also certain agreements that the JobKeeper scheme has put in place. It gives employers and employees the ability to make an agreement in relation to the times or days that the employee is required to perform work. So you can potentially, as an employer, enter into an agreement and say to an employee, look, we don't need you to work Mondays anymore. Mondays are really dead at the moment, but we're going to swap your working day till Wednesday. Provided the employee, provided that's reasonable, then the employee is essentially required to agree with that. And if they don't agree with it, they need to provide a pretty good reason as to why not. There's also an ability to enter into an agreement with employees who are receiving JobKeeper to take their annual leave. So you can again agree or request that they take that annual leave. The employee cannot unreasonably refuse that request. So it's not quite as strong as a direction. It is still a request, but the Act says the employee can't unreasonably refuse that request, as long as they're still left with a balance of 2 weeks annual leave at the end of it. Some other points to note: if an employee has been issued with a JobKeeper enabled direction, and perhaps they need a bit of, they're doing different tasks than they would normally, and they've asked for a bit of training or such, then you have to consider that request as an employer, and you can't unreasonably refuse it. Similarly with professional development, or if they seek your permission to undertake some form of other employment, you have to consider the request and you have to have pretty good reasons for knocking it back. And as I said, there will be penalties applying to employers who misuse the JobKeeper provisions. And at the end of the day, all the rules still apply regarding unfair dismissal, discrimination, general protections, etc. in the Fair Work Act. So none of that has been changed by these new sections. All right, so hopefully most of you are across the application process by now. We're right in the thick of it, and the deadline is essentially this Sunday. So how do you apply? Obviously, you all would have elected via the ATO website or registered way back when they first sort of announced the scheme, and the ATO application process is now open for you to go through, and you need to be able to provide that supporting documentation. You must register by the 26th of April to be eligible, I guess, for that first round of payments. And you need, in order to claim the JobKeeper subsidy for the very first, or the first and second fortnights, so from the 30th of March through to the 26th of April, so for those 2 fortnights, you have to have identified eligible employees, and you have to have paid them for that period of time as well. And then going forward, you'll need to continue to provide monthly reports to the ATO regarding your employees, eligible employees. And you'll also need to ask your employees to complete a nomination notice, which is available on the ATO website. We recommend sending it out with a form of communication to employees which explains what it's about. And also, I think potentially explaining to employees that just because you're nominating them doesn't necessarily mean you're going to be eligible as a business as well. There's some businesses out there who just don't know necessarily if they will be eligible, but they're going through the process nonetheless. So I think make that clear to your employees when you're sending out those nomination notices. But you need to get onto that straight away if you haven't already. A question we've been asked is, can I bring back an employee that I made redundant if we are eligible for JobKeeper, or do I have to? Am I required to? If that employee who is now made redundant was still employed as at the 1st of March 2020, and you are happy to re-employ that person, then absolutely you can. That's up to you. And that person, if they are brought back on and rehired, would be eligible for the JobKeeper payment. You'll need to go through the process of re-employing them in order for them to be eligible. But as long as they were employed as at the 1st of March, then you can do that. Now, the question then comes, well, what if you've already paid out their annual leave? What if you've paid them a redundancy pay? That's a matter for you, how you work that out between employer and employee, whether you seek to have that repaid. There's certainly nothing in any of the JobKeeper rules that addresses that situation, and nothing really anywhere else. So that would become a matter between the employer and employee to agree on. Okay, this is a fairly common question. I've got some employees that don't earn $1,500 a fortnight, so that's the JobKeeper amount. Do I have to pay them the full $1,500? And if I do, can I get them to work some extra hours up to that $1,500 worth? And also the other question is, well, can I just pick and choose who I pay that $1,500 to? Because if someone's not earning $1,500 at the moment per fortnight, why would I want to start paying them now that amount? So if you apply for the JobKeeper subsidy as an employer, you have to include all eligible employees within your business. You can't pick and choose. The scheme has been described as a one-in, all-in scheme. So provided an employee meets all of that eligibility criteria, they are entitled I guess you're entitled to that $1,500 subsidy for them per fortnight, and you need to pay that on to them. Now, obviously, that money, that $1,500 per fortnight, as you're being reimbursed by the government, you're having to find that out of your cash flow. So we're really urging people to closely consider whether the JobKeeper scheme is right for you and for your business, and to get the right advice. Are you open? Are you trading? Have you got people stood down without pay and your cash flow really is minimal or non-existent? Have you got access to bridging finance? All those sorts of questions are really, really important when you're considering whether or not this scheme is for you, because you will need to pay that $1,500 to all eligible employees. And you must pay on that full $1,500. You can't just pay on the amount they ordinarily would have been paid and hold back the rest. You can ask employees who would have ordinarily earned less than the $1,500 per fortnight to perform work that is safe and reasonable. In order to increase their hours, though, from what they did previously, that can only really be done by agreement. So whilst you can, under JobKeeper, you can reduce people's hours by direction, you can't direct people to increase their hours. That has to be done by mutual agreement. So again, you need to really take into account if this scheme is for you. You might have a lot of people who don't earn $1,500 per fortnight. Maybe the work isn't there to be done. So consider whether it's going to be the right thing for you. But again, if you've got reasonable relationships with your employees, you may well find there are some that are quite happy to do a bit of extra work while they're in receipt of that $1,500 per fortnight. I've stood down my employees due to a forced government closure. If they will be paid the $1,500 per fortnight, can I direct them to do a bit of online training at home or come back in to do some work? Yes, you can. Sorry, I'm just mindful of the time. So we're getting sort of towards the end. Stay on the line if you can. For those of you who may need to head off, we will absolutely send you out the recording after today. But if you can stay on for another 15 minutes or so, we'll make sure we get through the rest of this and some questions as well. But yes, JobKeeper effectively enables you to bring employees back on to your payroll. It is possible to direct employees to perform work if it's available in consideration of that JobKeeper amount, provided again you're not asking them to work more. You're not asking them to work more than the equivalent of a $1,500 per fortnight amount based on their usual hourly rate. So you work out what the hourly rate is, you work out what equates to how many hours that is, equals $1,500, and make sure that they're not being asked to perform any more than that. Otherwise, if they're performing more work than that, obviously you need to pay them accordingly. Any duties that you request that employee to undertake mustn't be unreasonable. So they've got to comply with any work health and safety requirements. They've got to have the ability, the skills, etc., to be able to perform those duties. And you can also ask employees to work from other locations, such as work from home or perhaps at other locations, work sites, provided it doesn't require unreasonable travel on the part of that employee. So we've got some employees who might earn less than $1,500. We've got some who might earn more. So if you've got employees who are still working and they earn more than the $1,500 per fortnight, you have to just pay them as per usual, continue paying them their normal rate, and the $1,500 basically will just subsidise their salary or their wages that you're paying them. Superannuation, do I have to pay super? Where an employee is paid more than $1,500 per fortnight for work that they're actually performing, your superannuation obligations don't change. So that situation I just mentioned, you would pay super on that full amount. They're performing the work, it's ordinary time earnings. Where an employee is earning less than $1,500 for work that they are performing, so again, they're actually working, and you're topping them up to that $1,500, it's essentially up to you whether you want to pay super on those additional wages. Sorry, I should just clarify that. If they're performing the work, you have to pay superannuation on any work that they perform. If you're just topping them up and they're not actually performing work to the value of $1,500, They're only required to be paid for work that they're actually performing. I've got some employees who are taking annual leave while business is quiet or some operations are shut down. Does JobKeeper apply to them? Yes, so the JobKeeper payment will subsidise any payments of annual leave that you're making to eligible employees. If the employee is entitled to an amount in excess of $1,500 in respect of that leave while they're on annual leave, then obviously you need to still top up the difference. But a JobKeeper enabled stand down direction, so to reduce hours, doesn't apply to an employee during a period that employee is taking paid or unpaid leave, if that leave is authorised by the employer. So you must continue to pay them their ordinary leave entitlement and then top it up if required. You can request an eligible employee take annual leave during a stand down. And as I mentioned before, that employee is not able to unreasonably refuse that request under the JobKeeper provisions, provided they left with 2 weeks annual leave remaining. So I stood people down on the 30th of March. I haven't got the cash flow to pay them the $1,500 per fortnight until I actually get the money through from the government. Will the payments still be backdated to the 30th if I haven't paid them any wages? No, the answer is no. If you haven't paid though for those first 2 fortnights by the relevant date, by the 26th of April, then you won't be able to claim the subsidy for that back pay. You can claim it at a later date, but for that period of time, no, you have to have made those payments. So the first fortnightly period for which payment must be made in order to claim the subsidy is that 30th of March to the 12th of April, and then the second fortnight is the 13th to the 26th. So as long as you've made that payment by the 26th of April and you're eligible, of course, then you will receive that subsidy. So I've got employees who are stood down, they're not coming into work at all, and they're receiving the $1,500 per fortnight. Do they accrue annual and sick leave entitlements? Yes, they do. So they would continue to accrue those entitlements just as they would if they were working at their ordinary hours. Now, this is a question that came through before today. If the Australian company is the employing entity, but is part of a global organisation, is it eligible if it can only meet that 30% threshold? Yes, so the 30% or the 50% reduction in GST turnover test is applied on a per entity basis. The company applies the 30% reduction test if its aggregated turnover is less than 1 billion. And to determine whether the company's aggregated turnover is less than 1 billion, you must include the turnover of its global related entity. What about an employee who's on unpaid parental leave? Are they eligible to be paid the $1,500 per fortnight? Yes, they are, unless the employee is already receiving paid parental leave from the government. So if they're already receiving that, then they don't get JobKeeper. If their paid parental leave, so their 18 weeks government paid parental leave runs out, and they're still not back at work, and they're still on unpaid leave, then yes, they would receive the JobKeeper. What about commission? I have an employee who receives commission. Do they need to be paid the $1,500 per fortnight plus commission? The eligible employee must receive the full $1,500 before tax per fortnight. As to whether they receive the commission on top of that amount, that will be firstly up to you, the employer. It also needs to be in compliance with any agreement regarding payment of commission that you've got in place with your employee. So check what's in writing there. And it also needs to be in compliance with any base wage or minimum wage requirements under any relevant industrial instrument. What about apprentices and trainees? Are they eligible? Yes, they are, again, provided they meet all of those eligibility requirements, but they can't claim both the JobKeeper subsidy and the supporting apprentices and trainee wage subsidy at the same time. That brings us to the end of our, I guess, presentation, the questions that we have built in, I guess, from all of the questions sent through beforehand today. So what we'll do now is open it up and I'll have Sarah back on the line and Neil on the line, who are going to, I guess, read out perhaps some of the questions that have come through today, and we can see if we can answer any of those for you that haven't already been answered. Thanks, Sarah.
Thanks, Cecilia, for that insightful presentation and answering a lot of questions that we've had passed through. We've answered quite a few questions along the way, but I have got a few here that I will ask. I have one attendee who has an employee who is not going to reduce their hours or by agreement. They're not eligible, the employer is not eligible for the JobKeeper, and they're wondering, when they have one employee out of a group who's refusing, what options can they do to try and deal with that person, and given the financial requirements to look for savings.
So in that sort of situation, really, as an employer, you're faced with a decision where you could argue as an employer there is no longer a need for a full-time, or whatever they're, let's, for example, assuming they're full-time, there's no longer a need for a full-time role. Effectively, it's a redundancy situation, so that the need for the full-time role is no longer there. What is on offer is redeployment into a part-time or reduced hours role. If the employee isn't wanting to take up that offer, a redeployment into that reduced hours role, then it becomes a redundancy situation, and it would trigger the necessary, I guess, redundancy process around consultation and redundancy payment if that's relevant for that business. And look, this has come up, and when I said before, most employees are being fairly understanding at the moment of the need to take a bit of a hit temporarily for the greater good. You will find some employees that just aren't. Perhaps they're just not able to financially. But I think in the conversations with them, it's just a matter of really just pointing out that if they're not able to come to the party and actually reduce their hours, it might actually mean there is no longer a role available for them in the business.
Okay, thank you for that. Another question from the participants. When on JobKeeper, can you have an employee doing fluctuating work when there is work available and then reduce to nil when there is nothing available?
Yeah, definitely. So that flexibility is there and built into the JobKeeper enabled directions. There's no statement in the provisions which says a JobKeeper enabled direction to reduce hours has to be fixed for a period of time, or it can certainly be negotiated and, I guess, yo-yoed up and down according to the needs of the business. That's the whole intent of the amendments to the Act, to provide that flexibility. So as long as you're regularly communicating with your employees about what's required, the hours, the duties, and regularly reviewing that based on the business needs, that's the key. Just that regular communication and documentation of those requests as well.
Great. Neil, I posit this one for you. We nominated as being eligible for the JobKeeper for April about a week ago, but our sales are now better, so we'll not meet the eligibility for April. How do we change our turnover method to quarterly from 1st of April, since we think we will qualify for that period instead?
Yeah, so that one there, I mean, there's no requirement to either use a month or a quarter. It's really up to you. And essentially what the government's done with the rules in relation to JobKeeper is made the gate as wide open as possible to get as many people in. And then they're focusing on the eligible employees and controlling the payments that way. So what they've enabled you to do is you can have a look on a month-by-month basis. So you're comparing, say, March 20 to March 19. If you fail that, you can then project forward to the next month. So you could project for April and say, am I going to meet it for April? And in this case here, they're saying, well, they probably won't, even though they thought they might have. But if you fail that projection for the month, you can then project for the quarter. So you can go along and project for the June quarter overall, have you got a 30% reduction or not? And if you have, then you're in. Now, importantly, once you're in, you're in. So you only need to satisfy 1 month or 1 quarter, and you'll be in from that point forward until the end of the entitlement in September.
Okay, thanks, Neil. Cecilia, one question about probationary periods for people when this 6-month period falls within this COVID time. Can their probationary period be placed on hold during the stand down? Otherwise, of course, there's the unfair dismissal claim.
That's a good question. So,
yes.
yeah, so I guess the question is, does the probationary period get extended out
Yes.
by virtue of the fact that they've been stood down? My view would be yes. So the purpose of a probationary period is obviously to have 6 months to assess somebody's performance in a role. If for 3 of that 6 months they haven't been able to work due to no fault of their own, it would seem to make sense to me that probationary period would be extended out. From a practical perspective, in terms of assessing someone's suitability for a role, where it might become difficult is where you seek to terminate somebody at the end of the probationary period and they've already completed technically more than 6 months service. In that situation, I don't think you'd have the ability to, or I think the employee may still have the ability to access the unfair dismissal provisions.
In the extended period.
Yeah, that's right. So I think probably bear that in mind when you're looking at, adding on to, I guess, a probationary period. So there's sort of the practical reasons why we have probationary periods to assess someone's performance, but then we also know that there's the legal implication if we let it run beyond that 6 months.
Yeah.
Hope that answers that question. Yeah.
Yes, thank you.
Question.
As a consultant, this is for Neil, as a consultant with turnover fluctuating monthly, how would the ATO assess a 30% reduction in a month relative to this time last year?
Yeah, so this is an interesting one. I mean, what the basic test does is it's just purely a test of saying what was your turnover this year compared to the same period last year, right? So there's no requirement to show it's as a result of COVID or anything along those lines. It's just purely a basic arithmetic sort of comparison. So in that instance there, that's what you'd need to do is you'd need to have a look and say, okay, well, have I reduced by 30%? The Commissioner does have discretion though, and there are alternative tests, but they keep promising some guidance on these alternate tests, but we haven't seen anything come out as yet. So we'll just have to wait and see how that gets applied in practice. But ultimately, it's just a case of having a look at this period versus last, and if you drop, you're in.
Okay,
unless you want to go to your projected turnover for the quarter.
Yep. Okay. That's really all the questions we have. Most of them have been answered online as we've been going. So thank you, Neil and Cecilia.
All right, thank you, Sarah, and thanks, Neil, for joining us, and thanks everyone for joining us today. Hope you found it useful. Just if you are looking for more information, more guidance, if you've got questions that are really specific to your business, don't hesitate to reach out to us. There's also a lot of information updated on a very regular basis on our Perks COVID-19 hub, and you can see the link there on the slide. There's lots of articles, alerts, updates. We're uploading lots of FAQs as well. There's also some resources specifically for employers around workforce management. So there's an employer toolkit, employer advice support package to help people through the next few months as well as lots of other useful links and resources. So make sure you get online and have a look at that, and don't hesitate to get in contact with any other questions you might have. Everyone will get the recording after today, so you'll have that to refer back to if you need to. So thanks everybody again. I hope you'll have a great day. Take care and stay safe. Thanks.
Thanks everyone.